Bismillahirrahmanirrahim. Assalamu alaikum, dear students. Our today's lecture is on contract and its essentials. In the previous lecture on the same topic, we discussed the first 5 essentials of a valid contract, that were offer and acceptance, legal obligations, capacity of parties, free consent, and lawful consideration. While in today's lecture we will discuss lawful object, writing and registration, certainty of terms, possibility of performance, expressly declared, void. But before starting our discussing the remaining 5 essentials, after this lecture you will be able to understand what you will conceptually understand the characteristics and essentials of a valid contract and legal agreement. Now coming to these are the remaining 5 essentials of a valid contract: offer and acceptance, legal obligation, lawful consideration, capacity of parties, free consent. Coming to the first topic, that is lawful object, writing and registration, certainty of terms. Now, what is lawful object? The agreement must be made for a lawful object. The object is lawful if it is not fraudulent, illegal, immoral, opposed to public policy, or involves injury to person or property of another person. For example, C promises to pay 5,000 rupees to B. For what? If B beats P. The contract is void and its object is illegal. The objectives is illegal. So, law ya court cannot accept it is a legal contract between C and B because the objective is illegal. That is violating someone's rights. Now coming to the next point, that is writing and registration. A contract may be oral or in writing. However, if the contract is in writing, it is easy to prove in court of law. A written contract was made between parties for sale of land but not signed by both parties. Now it's an example. The court held there is no contract between the parties since the written contract is not signed by both the parties. As I have told you, students, that any contract has parties, and it is only contract when it is done in writing or orally in front or verbally in front of whom? In front of witnesses. Now in this contract we see that there is a deal of sale between two parties in writing, but both parties did not sign the instrument of sale. So when the case goes to the court decided that there is no contract between the parties since both of them have not signed the instrument. So signing of instrument is mandatory for validating a contract in court of law. Coming to the next point, boys, the terms of the contract must be certain. Otherwise, if the terms of contract are uncertain, the contract is void. certainty is mandatory, that anybody can ascertain that about what the contract between the parties is going on. The court can easily understand from the words that what is the main object of the contract, who are the parties, and what is the price. Now if we see in the example, C promises to sell 20 books to B. Now in this contract, the contract is void. Why? As the title of books is not clear, as well as price. She promises to sell 20 books, but at what price, and what will be the titles of those books? The certainty cannot be ascertained from this contract, which is verbally or in writing between two parties. So court will declare it what? Null and void. It is no in this case there is no contract between C and B. It should be a certain books, number of books plus price. Now boys, coming to the next slide, that is possibility of performance. This is the next essential. A valid contract must be capable of performance. That if a contract is cannot be performed by one of the parties, then it is not a valid contract. For example, A promises to B to put life back to B horse by magic. So it cannot be done in the real world. So it is against logic in law. This contract will be declared void by the court. Any contract which cannot be performed by either party. Let's say if A wants to purchase Buckingham Palace, and B says that I will arrange this deal, but B cannot arrange that deal because Buckingham Palace is the property of the British royalty, and nobody else can sell it instead of them. Expressly declared void. Again, very important boys. The contract is void if among those contracts expressly declared void by what? Section 24 to 30. There are certain contracts which cannot be done. It may have all the requirements of a valid contract, but law prohibits such contracts to be executed. And one example is here. A promises to close his business if B pays him 2 million rupees. It is a void contract as it's restrain what? Legal trade. It against the spirit of free market economy. So law does not allow execution of such contracts. Hope you understand the contract and legal agreements, and then the essentials of a valid contract, and how a valid contract can be made, and how it is a useful instrument for the daily businesses. And I hope you will come up with some good questions in the live session tomorrow. Thank you, students.